Please the court. George Vaca on behalf of the appellant Josefina Gomez. I'd like to reserve 5 minutes for rebuttal if I might. And before I get into my argument, I'd also like to thank the court and my opposing counsel for granting the continuance of this oral argument that was scheduled last month. I had a conflict and the court was kind enough, as was co-counsel, to agree to reschedule this, so thank you. We're here today asking the court to reverse a final summary judgment entered in favor of the insurance company against my clients and remand with directions to conduct a trial or other proceedings consistent with the mandate. Excuse me. Factually, this case isn't that complicated. On July 7th of 2016, my client reported water damage from a January 2016 storm, and she first discovered the damage in July when she reported it, shortly before she reported it. The next day, Avatar sent an adjuster and a roofing expert to inspect, and they ultimately determined that there was no covered loss. On August 19 of 2016, Avatar sent a letter to the client denying the claim and denying that there was a covered event under the policy. Thereafter, the client's public adjuster, Mr. Sims, submitted photos and an estimate of the loss as well as a sworn proof of loss. Avatar sent back a copy of its August 19 letter saying no coverage. The client then filed a CRN with the Department of Financial Services in October. And then on Friday, November 18, 2016, Kurt Allen of the Butler Pappas firm sent a letter to my client's lawyer at 7 o'clock in the evening on the Friday before Thanksgiving, demanding that the client produce all sorts of sets of documents, that the client appear for an EUO on November 28th, which was a 3-business day notice, that the public adjuster appear, that some people with the Keys evaluation team, another person the client had hired, all appear for EUOs. Can
I ask you a question, Mr. Vaca?
Yes.
And I appreciate the recitation of the
Sure.
facts, but you know, you all did a really good job in your brief laying that out. So if you don't mind, I'd like to kind of get to the key issue.
Sure.
You know, we have our decision in Castro, which addresses a case very similar to this situation, except for in Castro, the issue was whether or not that was a reopen, where here we have a rescission of a denial.
It's a different label. It's the same thing. There's nothing in the policy.
Well, a reopen suggests to me that new information was found. It was submitted to a carrier and said, hey, would you reconsider this because we found some new stuff. And in Castro, it was a new engineering report. You don't have that here. You have an outright denial, as far as I can tell by that August 19, 2016 letter. And then you have a rescission, complete rescission of the denial. Why does that not put everybody back in the situation they were before the denial? And there's no case in Florida that I can find that really covers this.
So I agree, and I think the answer to your question is you can't put the post-loss obligation genie back in the bottle after you've opened the bottle with the denial. So that denial was a waiver of all of the post-loss obligations. There is nothing that I'm aware of, and certainly no cases cited by the insurance company, that would say that after a denial, an insurance company can unilaterally say, no, we made a mistake, there's a contract. There's just nothing, I'm unaware of that in contract law. If I reject an offer, there's case law from this court that says, hey, wait a minute, you can't just then revive it and accept it the next day after your rejection. You're done. The effect of your rejection is a permanent one unless there's a new offer by the offeree. We don't have that, or the offeror, excuse me. We don't have anything remotely like this. We have a lawyer who says, we changed our mind, and now you need to comply with all these obligations on the timeline that I've set. And if you don't withdraw your civil remedies notice, remember, he ties it all into the civil remedies notice. If you don't withdraw that, if you don't waive your rights otherwise under the law to hold us accountable.
But we have no case in Florida that you and I have agreed on that addresses a rescission of a denial. We have no contract language in this case that addresses a rescission of a denial. And we have no statute in Florida that addresses a rescission of a denial. So it's down to just kind of what we all think.
Well, I think, no, I don't think it's where we all think. I think there has to be, in order to authorize this, whatever this is, a rescission, it has to be in one of a couple places, right? The right to do that has to be first in the policy, or it has to be in a statute, or it has to be a common law. It's in none of those places. It's clearly not in any statute. It's clearly not in this insurance policy. And the right to unilaterally rescind your breach is unheard of in common law, to the best of my knowledge.
But isn't it in a policyholder's best interest for an insurance company to be able to say, you know, we made a mistake on that denial. We need to withdraw that and start all over again and take a look at this. Wouldn't that benefit the policyholder? And aren't we supposed to construe this policy so when in doubt in favor of the policyholder?
It might or it might not, like in this case, where this rescission was used in order to harm the policyholder and the policyholder's rights under the civil remedies statute. So under the civil remedies statute, the insurance company could have done, in responding to this civil remedies notice, could have said, hey, we're going to pay the damages. They have an absolute statutory right to do that. They didn't do that. They wanted it both ways. So they wanted to avoid the penalties of the civil remedies statute, but by the same way, sit on the fence and say, hey, wait a minute, we're not denying this claim. That's the same part of the argument that they make with the claims administration statute that has no business in this case. Okay? But that's where we're really at. So once the civil remedies notice gets filed, their choice is to do one of two things. It's to either cure the violation, which they didn't do, or respond and deny, which is what they did do. So in these circumstances, I don't really see where you get the right to have a third option, because that statute clearly doesn't provide that option. Their option was to pay and cure the damages, or to explain why there was none. And they opted for the second one.
Let me shift on you now and go to the summary judgment motion. What are we supposed to do with the fact that your client files no affidavit in opposition to the affidavit supporting, or files really nothing?
Sure.
Files some emails were filed that were never authenticated and things like that, but there really nothing is filed, which always baffles me when a lawyer does that, doesn't really respond to a summary judgment motion, and their sole avenue is to attack the affidavit of the one filed by the opposing party, which in this case was a pretty thorough affidavit by a person. I know that you've taken the position this person didn't have knowledge of the facts, but it appeared that this person was very much in the position to have this knowledge. So help me with that.
Sure. Well, let's remember, there were two summary judgment motions filed. The first one was no breach of contract. That clearly was an error. I mean, under a long line of decisions from this court, McKee, Herrera, all sorts of cases. Once the insurance company denies the claim, the cause of action for breach accrues. So that summary judgment should have been denied as a matter of law. And I'm not telling my opposing counsel anything she doesn't know. She was counsel on those cases. Okay? So that one should be reversed right out of the box, because it's just flat out wrong as a matter of law. So now we go to the second one. And the second one deals with the Castro issue for sure. There's no question about that. So the next question is, okay, does the denial waive those post-loss obligations? In Castro, the court said it did. In Castro, then the insurance company in Castro tried to explain it away by saying, no, we didn't do that, we were actually reopening. And this court said, no. There's nothing in the policy that talks about that. There's nothing that is letting the insured know, which is why I think we have to go back to Castro. There's nothing that lets the insured know that from now on, game on, and if you don't comply with these post-loss conditions, you're going to forfeit your coverage. That was one of the prevailing public policy reasons I picked up from in the Castro decision. We don't have any explanation to my client that she is going to now forfeit coverage she otherwise has if they don't comply with this November 18th letter.
What do you do with the court's finding that they're on the post-loss compliance aspect where the court finds, and I'm looking at the transcript, that the insured failed to provide Avatar with prompt notice of loss and found a material breach on that? That's the very first holding the court finds right out of the gate, and then goes on to note that there's no competent evidence from the other side to refute that. So I'm not sure, because this loss happens, I guess there was some confusion. Sometime in January, 2 different dates are given, and then but the claim isn't made until July.
There's only one date that's given, Your Honor. There's nothing in this record that I found. Avatar says that there's 2 different times given, but there's no evidence to back that up. There's no recorded statement like they said they took from the insured. There's nothing in writing that the insured ever said. But it's a week off. Either way, it's January.
It's January.
Okay.
The 2 dates are within 10 days
Correct.
of each other in January. We don't hear anything about the claim until July.
Mm-hmm.
And it looks to me like the judge, that's the first thing the judge picks up on is you've got a late notice, which is a material breach, and nothing filed in opposition. So why doesn't that carry the day?
Well, because I would suggest, Your Honor, take a look at the Himmel case out of the 4th DCA. Exact same lawyer, exact same insurance company, exact same policy, exact same argument, no prompt notice given. The 4th District, in reversing one of the summary judgments that Mr. Allen bragged to this judge that he had obtained, said, wait a minute, whether a notice is prompt is almost always a fact issue for the jury, particularly when that term is not defined in the policy. And the court went on to say, with respect to prompt notice, notice is prompt when it is provided within reasonable dispatch and with reasonable time under the circumstances. Reasonable time under the circumstances. That's a fact issue. There's no evidence in this case that my client noticed water damage in January.
I think Mr. Allen put that in his memo, but I don't know where that came from. There was an allegation that the water had been leaking all along since January. I read that somewhere.
It's in his motion, but there's not.
Motion.
It's not supported by any attachment to the motion. It's not supported. It's directly refuted by the affidavit of Mr. Sims, who was the public adjuster, whose affidavit was filed, I believe, with the rehearing motion, because the judge had said, hey, you didn't authenticate any of these emails and all that other stuff going back and forth where they were desperately trying to reschedule these unilaterally set EUOs. And so Mr. Sims clearly said that Mrs. Gomez advised him that she had not discovered that until the day she reported it or shortly before that. But it's reasonableness under all of the attendant circumstances. That's a fact issue. That's another reason why this summary judgment was wrong. So even if we go to the notice issue, that one too should have been denied as a matter of law until there was sufficient evidence in the record to show when this person actually had notice of the loss.
Before the court gets to the rescission issue, the court identifies a second basis for the granting of the summary judgment, which was the failure to submit a sworn proof of loss.
That's just...
And again, pointing... And I think what Judge Morris mentioned a minute ago, and I'm sure, knowing you've been at this a while, you've figured out that this judge leaned heavily on the fact that nothing sworn was filed in response, which is usually a pretty good argument on a summary judgment. So the court makes a second finding, failure to submit a sworn proof of loss with no countervailing evidence filed.
Okay, well that was just wrong because there was a sworn proof of loss factually that was submitted by Mr. Sims on August 22nd of 2016. I believe that was referenced in the hundreds of attachments to the summary judgment motion, but it again was referenced in the motion for rehearing for sure.
You're at 15 minutes, just so you know.
Okay, so let me wrap this up. So there was something that was submitted to the insurance company. Remember, it's Mr. Allen who says in his November 18th letter that it was a nullity because it wasn't on their paper, okay? But he acknowledges that there was some effort made by the insured to comply with the insurance company's request. So that letter is clearly in evidence. They relied upon that, and it demonstrates that there is some effort to comply with the request being made by the insurance company.
Okay.
If the court, I want to stand on the affidavit arguments that we've made in the brief. They filed a motion or a notice of supplemental authority yesterday of a third DCA case involving citizens. I'm surprised that they've filed it. I think it actually supports the position that we've raised, which is you can't support a summary judgment by an affidavit that's based upon mere conclusions without evidence and the like.
I think
With
most
that,
of the rest of these issues.
I'll be seated. Thank you.
You'll have 3.5 minutes when you return.
Your Honor.
Good morning. May it please the Court, Carol Rooney for the Appellee Avatar Insurance Company. The standard of review is always critical, but it's especially critical in this case. Judge Morris, I think you hit the nail on the head when you discussed what was the trial judge looking at the time of the summary judgment hearing. There was nothing filed in opposition. The summary judgment rules are clear that in order to rebut summary judgment, you need to file your affidavits at least 2 business days before the hearing, and there was nothing there. So, and the Gonzalez case that we filed a supplemental authority on makes it also crystal clear that the burden shifts. We submitted the affidavit of Avatar, the corporate representative, and she goes through the facts of the claim and she details all of the problems and the issues. And that was fully supported at the time of summary judgment. When there's nothing submitted in opposition, Judge Sanko was certainly within his rights to say summary judgment is warranted on all of these grounds, getting to whether or not you can reopen a claim.
Well, a number of them are legal bases. I think a number of the bases that he cites in his ruling sort of lives and dies on this Castro issue. I mean, if there's no further obligation once there's been a breach, then he's just wrong on all these others. So I'm not sure that applies to all of the arguments, but it does apply to quite a few of them.
Well, let me address Castro. Here's the critical difference in Castro. In Castro, the insurer just assumed that the claim was reopened based on the insured submitting additional information. There was never any explicit written correspondence to the policyholder, the insured, saying, we are reopening your claim, we are rescinding your denial, explicitly saying we're taking a second look. That's what we had in our case. And I agree
that your letter is more clear, but what I am curious about is whether there's any authority allowing that you would cite authorizing the company to attempt to reinstate all the obligations once they have informed the insured that there is no coverage.
I believe the provision in the policy that discusses reopening claims is broad enough to encompass this. Okay. Because it's basic, and when you look at the time frame, it's literally within weeks. You have that letter that whether you construe it as a denial, basically it's saying, we can't pay you at this time based on what you've been presented.
But in this case, we have a denial of a claim, then we have a lawyer gets involved. Lawyer writes a letter, then there's this attempt to rescind the denial. You know, I'm getting cynical as I get older, but it looks like gamesmanship to me. Help me understand that, because it would seem to me that if we were to support this, it would allow an insurance company to sort of deny a claim and rescind a claim at their convenience based on whatever their strategy is. Is that something we should be worried about?
I don't think you should be worried about that, Your Honor, because this actually serves the policyholders, it serves public policy. It's basically allowing an insurance company to say, we'll take a second look, because the alternative is we'd have
Well, they can take the second look, they're just not entitled to hold their insured to all the pre-claim requirements in the policy. That they've, Castro says all bets are off, that's done. That doesn't stop an insurance company from going back and saying, hey, we'll talk with you, we'll continue to look at this, or once they've made the denial, it's kind of over, isn't it?
Well, the problem with that, Your Honor, is that a policyholder could secret or fail to provide the information in order to properly investigate and adjust the claim, and then they get a letter saying, we're not going to pay you, or your claim is denied, then all of a sudden you have all this other additional information, and then it becomes a litigation issue.
Well, like in this case, we have the unilateral setting of the EUO within a really short time frame and a demand for a huge amount of information to be presented in advance of that, an unrealistic time frame, it seems like. And that's why it looks like gamesmanship, the effort to basically challenge the insured for not complying with this. And that's concerning, there's a lot of that stuff that goes on, as we all know, and our concern is to sort of not to foster that, if at all possible, particularly in an area like this where we have no case, no statute, no policy language that's addressing this. And I sort of feel like this is going to be whatever we all think it is.
Well, Your Honor, Avatar did agree to reschedule the EUOs if the policyholder would withdraw and refile the CRN. They didn't have to withdraw it completely, but reset that 60 days, because that 60 days, that's statutory, and that's why that's properly legally decided by the trial judge. And again, keep in mind, the trial judge granted summary judgment based on the unrebutted record before it at the time.
Do you think that's your strongest argument?
I think it's a huge argument here, and one that probably is our strongest argument, because everything that Ms. Davarka just discussed is all based on their motion for rehearing. That's discretionary. Judge Shanko certainly had the discretion at the time of the motion for rehearing to say, I'm not going to consider all of this. I have the discretion not to consider these 11th hour affidavits, and I'm not going to do that. And I think trial judges should be allowed to do that. The summary judgment rules exist for a reason. They're crystal clear, and if you choose not to comply with them, you do so at your peril. Ms. Gomez's counsel stated at the hearing that she decided not to file any oppositions to the motions for summary judgment because she thought our corporate rep affidavit was improper and insufficient. Well, that was a risk she chose to take. I mean, and she took that at her peril. So yes, I actually think that is probably our strongest argument, and you could affirm purely on procedural grounds to say this trial judge made the decision to grant summary judgment based on the unrebutted record before him, period. And he did not have to consider these affidavits at the 11th hour, and he didn't. You're not even entitled to a hearing on a motion for rehearing. So purely based on that, you could affirm and just leave it at that and not even get into prompt notice and all of that. But assuming you did want to go to the merits and have de novo review of all this evidence, which frankly I don't think this court should engage in. I don't think Ms. Gomez is entitled to have this court, the appellate court, consider for the first time all of this evidence that Judge Shanko said, you know what, I'm not going to consider it. It wasn't timely presented to me. I don't think Ms. Gomez is entitled to that. That was a risk that her counsel took, that she signed off on, and that concludes the case. So really, this court could write, if you decided not to PCA, but affirm, could just write based purely on the summary judgment rules. They exist for a reason. And this Gonzalez court made it crystal clear. And also to distinguish Himmel, my opponent mentioned Himmel. In Himmel, the court specifically says that, refers to the summary judgment evidence submitted in opposition to the insurance company's motion. So they had summary judgment evidence.
Is that the one you were on, Himmel?
My colleagues were on that. Yes, sir, Your Honor. But that was a critical difference. Again, at the time of the summary judgment, they have competing affidavits, they have competing summary judgment evidence. We do not have that in this case, and that is a critical issue. And as far as whether or not you can reopen a claim, I agree, Judge Morris, that there is no case exactly on point. I don't think the Florida Insurance Code expressly addresses this. I do think that the provision in our insurance contract distinguishes from the other case because we do actually define reopen claim. In the Castro case, they don't define that. I think it's broad enough. It's not perfect because I agree, because you're saying it's a rescission as opposed to reopening. That might be a distinction without a difference. I think the fact that the insurance company says we have, if we decide to reopen the claim, we can reopen the claim.
It seems like the cases, though, that do analyze what a reopened claim is are pretty strict about it. It seems like that more often than not, they kind of don't find a claim has been reopened, like in Castro. So that being the case, it seems like that the case law is that, a denial is a denial is a denial, and it's really hard to undo a denial, even with an attempt to reopen.
I think the distinguishing feature is the sinkhole cases are different. The Castro case, again, there was no written correspondence or communication to the insureds whatsoever saying, we are reopening your claim. We did that in this case, and we did it within weeks. Now, I would agree that if Ms. Gomez would have immediately filed suit after receiving that letter saying, we're not going to pay you, I'd have a much tougher argument. And I would agree that if it was years down the road, all of a sudden, we said, we're going to reopen your claim, I'd have a much tougher argument. But if we're going to look at this on a case-by-case basis, based on our policy language and the undisputed record in this case, we have the insurance company saying, unequivocally and unambiguously, we are going to give this a second look, we are rescinding our denial, and we are reopening your claim. And they proceeded with additional investigations, communications, and all of that is detailed and documented in Avatar's corporate representative affidavit. So that's what Judge Shanko relied on when he granted our motions for summary judgment. First of all, no breach is a matter of law because under Florida law, as long as the claim's still in the process of being adjusted and not concluded, your cause of action has not accrued. And that's the basis for no breach is a matter of law. And at the time of summary judgment, based on Avatar's corporate rep affidavit, that was the case. They had reopened the claim within a matter of weeks. They're still in the process trying to adjust, get everything investigated and concluded, and they're hit with a lawsuit. So that's the basis for no breach is a matter of law. As far as prompt notice, late notice, prejudice is presumed to Avatar. So the burden then shifts, based on the authorities cited by my opponent, the burden shifted to Ms. Gomez to rebut that presumption of prejudice.
Let me ask you a question about the notice. I'm looking at the motion for summary judgment, Avatar's motion, paragraph 16. Then on July 7, 2016, finally plaintiff told Avatar about the supposed loss. Again, this was some 6 months after the supposed loss allegedly occurred, and this is the key part. And with the roof reportedly leaking all the while. Do you know where that comes from?
Yes, that's in Ms. Kundro's affidavit at the record at page 1120. That's verified by Ms. Kundro. It's in her affidavit.
Kundro affidavit.
Yes, yes, sir. So again, all the investigation of the claim, the dates, the time frame, what happened and when, is all documented and detailed in Ms. Kundro's affidavit, and that was accepted by the trial judge. And again, his decision to accept it or not is purely discretionary. The standard of review, again with a motion for rehearing or a motion to strike an affidavit, discretionary. And Judge Sanko did not abuse his discretion. They have not shown that in him considering this affidavit. And so, again, we have no breach as a matter of law. That's fully supported. Late notice, the prejudice is never rebutted. So we get to, and when it comes to the post-loss conditions, even if you reject EUO or the sworn proof of loss, all we had to do was establish one of those was correct, and we win on that. I don't have to prove to you, or we didn't have to prove at the trial court all of them, prompt notice, sworn proof of loss, or the EUO rescheduling. But again, it was unrebutted. Judge Sanko had nothing but Ms. Kundro's duly sworn corporate rep affidavit in front of him to show that none of these things were complied with. The sworn proof of loss that was referred to by my colleague as in terms of the public adjuster said on its face, partial. It was incomplete. And then also in Ms. Kundro's affidavit, she verifies that Avatar was told that no further proof of loss would be submitted. As for the EUOs, she documented the problems with their refusal to withdraw and refile the CRN. They were refusing to provide all of the different representatives of Keys public adjusters. They specifically refused to provide one person that was at an inspection. So again, we have all this unrebutted evidence, summary judgment evidence, and I really do think that that is the strongest basis. This court need not get into the weeds, and Ms. Gomez is certainly not entitled to de novo review of all of this evidence that Judge Shanko properly said, I'm not going to consider it because they have not complied with the rules. That's really all I have. I think that sums up my argument. So unless the court has any further questions for me, I would respectfully request that you affirm the final judgment in favor of Avatar. Thank you.
3.5, Mr. Vaca.
Your Honor is concerned about gamesmanship. So is Judge Griffin back in the Whistler's case versus FIGA. Okay, she recognized that there was a cottage industry of defense lawyers attempting to set EUOs and bait the insureds into not be able to perform. And Judge Griffin back in 2012 questioned whether that was doing anything for search of the truth. I agreed with her then. I agree with your question now. If you want to see an example of gamesmanship, take a look at the Himmel case and take a look at what happened in this case. It is a prime example of the type of gamesmanship, not only that will happen, but did happen. Second point. It's amazing to me how easy it is for people to disregard what the law is. Our Supreme Court in Curran made it quite clear that the insurance company, not the insured, has a burden if there's a failure to cooperate. That burden is on them to come forward and demonstrate that there's been a couple of things. First and foremost, the insurance company must show that there's been a material failure to cooperate and that that material failure substantially prejudiced the insurance company. There is not a single fact in these affidavits to demonstrate there's been substantial prejudice to the insurance company. There's lots of conclusions. The affidavit she references is the affidavit in which they take the motion for summary judgment, put it in the form of the affidavit that talks about Merlin Law Group and all sorts of things that have nothing whatsoever to do with this case, and she signs that affidavit. That's why we said, yeah, look to the supplemental authority that was filed yesterday, because that was the exact type of affidavit that the court rejected. The court, excuse me, Your Honor, you asked me a question. I started thinking about it. What if they wanted to reopen? There's a better way to do that. It's called a reservation of rights. Don't send out the denial. If you have the ability and the belief that you need to continue to investigate, send out a reservation of rights. It's in the very claims administration statute she cited you to. But they don't do that. They denied it. They don't get to be able to put that genie back in the bottle. We would ask the court that if the court doesn't find that its decision in Castro is controlling, we would then ask the court to certify conflict with Himmel if you are inclined to affirm based upon the arguments of counsel. Thank you.
Thank you both. Your arguments and briefs were very helpful to us, and we appreciate it.
Thank you.
We're going to change again.